by Johannes Mokotedi, our labor law expert. I'm not an expert, but I think the basic principle is that an employee must always act in the interest of his employer as part of his job. That is one of his tasks. So, interesting question, I think. What if you are aware that your co-employee did something wrong whilst at work? What are your obligations in that regard? I think there was a recent case dealing with that.
Yes, there was a case of Mukana versus AF Brands. It was before the CCMA, wherein an employee was dismissed for such a conduct. In labor terms, we call it a derivative misconduct, and the employee was aware about the wrong done by the other employee, and he did not disclose it to his employer. Now, what is derivative misconduct? Derivative misconduct is a situation wherein the employee is aware about the wrongdoing, such as theft, corruption, and he deliberately doesn't disclose it to his employer. Now, normally, or most of the cases are in situations where there are strikes. People will be on strike, and they will while they're on strike, they will continue to do wrong things, and the other employees being on strike are being aware of such wrong things, not disclosing it to their employer. Therefore, in this instance, derivative misconduct is normally what we call, it's secondary to the primary misconduct. Primary misconduct happening, the employee being aware and doesn't disclose. Now, what does the law say? The law says, as an employee, you have to be honest with your employer. You are duty bound to disclose any wrongdoing. Failure to such can lead to a misconduct and ultimately lead to a dismissal. In the case of Ngokana, there was a shortage in the amount of 5,000 in respect of the bank deposit to a security company, and the other employee informed the employee in question, and that employee did not disclose it to the employer. And the employer making inquiries, the employee kept quiet, deliberately didn't disclose, and ultimately there was a disciplinary inquiry and it was dismissed. His application at the CCMA was also dismissed to confirm that the employer was correct. Now, duty to be learned is that employees are duty bound to tell their employers of any conduct, of any wrongdoing in which they are aware about.
So you're basically obliged to split on your co-employees.
Yes.
And if you fail to do so and you are dismissed, then that would be a fair ground for such a dismissal. That's basically what the outcome of this case was.
Yes, correct.
All right, so please take note, all employees, I guess.
Yeah, thank you.